This is the fifth in the series, What Does Beit Din Do? This, however, will be somewhat different than the others in the series, in that it is mostly going to be about what Beit Din doesn't do and why. We're going to discuss the role of Beit Din in financial disputes. So the way I'm going to set it up is, A, I'm going to talk about why theoretically Beit Din should have a role in financial disputes. B, we'll talk a little bit about the history of that. Then we'll talk about the jurisdictional issue as it plays out in America. Why the jurisdictional issue as it plays out in America, in practice, at least in the Mammonot Orthodox community outside New York, has almost eliminated the role of Beit Din in Mammonot's cases, including in Boston. I'll talk about what the halachic move necessary to reinstate Beit Din in terms of Dinei Mammonot is, and then you can decide for yourself whether that is a move that you wish to engage in or not, what the alternatives are. Okay, so if you look at page 1, this is really where everything starts from. We have a story which says Aryeh found Rabbi Yossi presiding over coercion of divorces, meaning there were husbands apparently who were refusing to give divorces even back then, and Rabbi Yossi simply engaged in whatever coercive measures that he could. Aryeh said to Rabbi Yossi, "How can you do this? We are hityotot. Now, for these purposes, hityotot will mean people who don't have real smicha, which we talked about in the previous weeks, meaning that they were not ordained in a direct line of succession from Moses and the 70 elders, and that ordination happens only in Israel. So the Babylonian rabbinate, by the time of the Moraim, does not have anyone possessed of such smicha. How can you engage in isui gittin? How can you engage in coercion of gittin? But his presumption is that coercion of gittin is something that requires the status of smicha. But along the way, he quotes the following brayta. Right? You have a brayta which says Rabbi Tarfon used to say, "Kol makom she'atam motzei egoriyot shel avdei kochavim." I'm not going to bother translating the term egoriyot. In later literature, it almost always turns into erkaot. Afal pi shedineihem k'dinei Yisrael, iya tara shai lizakek lahem. Okay, so what matters to us is that line. It says that the beginning of Parshat Mishpatim, which comes seemingly out of nowhere, right? Parshat Mishpatim begins with the Ve'ela. We don't know what precedes it, and so we don't really know who the Lifneihem are. But the rabbis read Lifneihem as a statement that these are the Mishpatim which you have to place before the ordained set of judges. And they learned before them, the ordained set of judges, in contrast to two groups of people. A, Jews who are not ordained. That's really what the question of Yosef is asked. But the first stage, it says, V'lo lifnei avdei kochavim. Now, avdei kochavim literally is idolaters, but it has been understood throughout the tradition, so far as I know, that we don't really care what the religion of the Gentile courts we're talking about, nor do we care whether they are religious courts or non-Jewish religious courts, or whether they are purely secular courts. And the whole point of the statement is, even if the substance of their laws is identical to Jewish law, right? It's a flat-out jurisdictional claim that disputes have to be at least among Jews, disputes have to be submitted to Jewish courts. Now we have a trick to resolve the problem of ordination, which I think we mentioned previously also, that we discussed that we see our non-ordained judges as the agents of the past ordained judges, and therefore, since we're only their agents, they're still really judging it. But we don't extend that agency to secular courts. We assume they didn't extend that agency to secular courts. Okay, all very complicated in terms of the theory, but the practice comes out very simply that there is an a priori claim that any dispute among Jews, among any issue among Jews that requires a settlement among them, has to go to a Jewish as opposed to a non-Jewish court. And to my knowledge, nobody has really come up with a good theory that would distinguish between one kind of court and another. Interesting theoretical suggestion one could make that the tradition seems to distinguish only between Jewish courts and non-Jewish courts, and does not deal with the courts produced by a mixed electorate, which Jews are part of the group, right? So you have a court system in which Jews have full participation, but not full control. So far as I know, no one has made that argument with regard to the court system, so we'll take it as a given in the halakhic system that there is an absolute obligation of Jews to submit their disputes to a religious court. This then becomes codified. If you take a look at the Torah, the first line of the Torah, Chavav says, "Asur ladun b'fnei dayanei akum." Right, you're not allowed to judge before non-Jewish judges, and the Beis Yosef cites this as well. And then it comes into the Shulchan Aruch, Siman Chavav, where the first line is, "Asur ladun b'fnei dayanei kochavim muver kod shalhem." You're not allowed to judge before non-Jewish judges or in their court system, even if both parties agree. Right? Even if both parties want to go to secular court as opposed to religious court. Now, this has obviously been an issue for many generations, because when do you have the option between going to Jewish court and non-Jewish court? Generally, you have the option of going to non-Jewish court in an environment where the government is not Jewish. And in an environment where the government is not Jewish, it is likely that the Jewish court will have less effective enforcement power than the non-Jewish courts. It is also likely that the Jewish courts will be less possible. I wouldn't say likely. It is also possible that in at least some of those circumstances, the Jewish court will be less well overseen than the non-Jewish courts. So you have pragmatic reasons that you might want to go to Gentile court, which are that if you go to Jewish court, you're not really sure that your judgment will be effective. And sometimes you have justice reasons, that you really just don't trust the Jewish courts because there really isn't oversight on them, and so for all you know, the specter of bribery, influence peddling, all sorts of things like that may be more prevalent in the Jewish courts than the non-Jewish courts, if the non-Jewish courts have an effective civil service system and oversight, and you're living in a tightly enclosed ethnic unity. You also have a third issue, which is simply the frequency of cases, which is that, so here we should talk about what the purpose of law is. So there is a sense in which the purpose of law is justice. I mean, that probably people would say it's a very reasonable sense that the purpose of law is justice. But justice is a malleable concept. Justice often depends on people getting what they expect. Right? So if we make a deal, and that deal is predicated, whenever we sign a contract, that contract is predicated on a certain set of assumptions about how the contract will be interpreted, how the contract will be enforced, what will happen if particular circumstances come up, and all those expectations are generated by a prior set of legal decisions. If you have a system which gets very few cases, then it is almost impossible for people to predict what a court will decide in a given case. And so that's one of the problems when you have a small legal system that doesn't get enough cases. It's very hard to get predictability. Another issue is that if you have a society in which almost everybody goes to a different court system, so their expectations will be predicated on the secular court system. So if you go to a Jewish court, all of a sudden they'll be totally surprised. That's not what we bargained for. We entered into a contract on the assumption we would go to civil court. So for all these reasons, most of which have been applicable historically and not just in our day, there has always been a very strong temptation for Jews to resolve their disputes in secular court as opposed to rabbinic court, and you can find cases in which people try and do this. The Talmud already refers to it, and all through the Middle Ages, in the communities that have more integration, there will always be a temptation to go to civil court. As against this, there have been a couple of attempts in the literature where people tried to legitimate recourse to secular courts over religious courts. All of those were thoroughly stomped on by the most authoritative decisors. So if you start, so I think that any presentation of the tradition has to begin from the premise that all disputes among Jews have to be taken to Beit Din as opposed to secular court. Okay, but there is a reverse side, which is we don't want people to go to court pointlessly. Right? It's kind of silly to make people sit through a Beit Din case if at the end of it we can't do anything. Right? So it's only reasonable to take people to Beit Din in an environment in which the Beit Din has some kind of coercive authority. But if really if you can spend all your time and money going through a Beit Din case and at the end you have a scrap of paper that the other person laughs at, so it does no good for you, right? Nobody thinks that it's reasonable to force you to go through the charade, especially if you're an honest, right? If you're an honest person, you're going to it because you expect to pay if you lose, right? So we say that every time there's a court case between two Jews, and let's say there's a case between one Jew who really feels bound by Halakhah and another Jew who doesn't feel so bound by Halakhah. So the Jew who feels bound by Halakhah, right, has to win twice. He has to win in the Jewish court, which will do him no good practically at all, just be good for his conscience. And then he has to go through the exact same case in secular court. So that's silly. And just about nobody ever thought that you should have to do that. So you have already in Sif Bet of the Shulchan Aruch, it says, Hayta yad avdei chavim takifa. If the hand of the idolaters was strong, meaning that the Jewish courts have less coercive jurisdiction than the Gentile courts. Uval dino alim, and the person that you are litigating with is a strong man, is the best translation I can give, meaning is somebody who has the social capacity to resist any pressure that the Beit Din could bring on them. Meaning either that the person could resist the judgment, or the person could even resist appearing in court. So under such circumstances, Shulchan Aruch says is if the Baldin Olim and you can't save your money, right, practically you can't salvage your money in Beit Din. So the procedure that Shulchan Aruch sets up is says that what you should do is you sue him in Beit Din, and if he shows up, then you go through the case in Beit Din, and if he doesn't come, then you obtain a reshut from Beit Din, what we call nowadays a heter arkaot, and you sue in the Gentile courts. As we'll see in practice, if he shows up and doesn't accept the jurisdiction of the Beit Din in such a way that you can enforce it, that we basically cut that step out because it seems silly, and I think the Shulchan Aruch was working in a world where if you showed up, then there would be enough social pressure to make you keep the Beit Din. You couldn't force you to show up, but if you showed up, you would listen because the Jewish community would throw you out if you didn't. But in practice, there is this mechanism called the heter arkaot, which says that if we cannot compel you to judge in a Jewish court, then you are entitled to go elsewhere. Okay, and now the Shulchan Aruch has a third line. Are these still in the same order? Are you sure? Well,
Yeah.
Okay, I may have to make it up because there's some. Oh, I see what happened. Okay. Okay. Then there is a. Then at the end of the Shulchan Aruch Sif Daled, you'll see that he says again, "V'chol zeh sheyachol l'chufo b'dinei Yisrael." All this is so long as you can coerce him in Jewish courts. Al v'malo ve'alim. But if the debtor is a strong man, mutar l'machro l'ovdei kochavim. Then you can. Sell it. Then you can sell the loan to a non-Jew. We'll have to figure out why that line is important in a moment. Okay, so let's just take it as a given, right? That right now we have the basic rule is you have to go to Beit Din. A secondary rule is that if you cannot enforce your judgment in Beit Din, meaning if the other party refuses to accept the jurisdiction of Beit Din, then you can go to secular court. Okay. That seems like a fine solution, and it works wonderfully, right? So it's straight up, you have a dispute, you ask the other person, are you willing to go to Beit Din? Great, you're willing to go to Beit Din. You're not willing to go to Beit Din? Great, you're not. Okay, you're not willing to go to Beit Din. How do we resolve the problem of coercive jurisdiction in the United States? We signed a binding arbitration agreement. Right, so in the United States, most states will recognize the rulings of religious courts if both parties in advance sign an agreement appointing the religious court as an arbitration panel, so long as the arbitration panel is not deemed to be arbitrary and capricious in its judgment, and so long as it doesn't address issues in which the state has an overriding interest, such as child custody. So the practice of most Beit Din in the United States, and the practice of the Beit Din of Boston since I instituted it, is that we simply don't take financial cases unless both parties sign binding arbitration agreements in advance. And if one party is willing to sign a binding arbitration agreement and the other one isn't, so then we say, okay, that means that one of you is willing to submit to the judgment of the court and one of you is not. The one of you is not, since we can't force you, is an alim. And because they're not, right, so we treat them as a strong, right, there's somebody who has the capacity to resist the coercive jurisdiction of the court, and so we write you a heter code. And that's basically the way most cases go, is that one party comes to Beit Din, you send a summons to the other party to appear in Beit Din, and if they say they won't come, perhaps you have to, right, if you have hope, you send three summonses, but eventually you determine they won't come, you write the other party permission to go to court, and it's not a great system, but it's not, but at least there's no injustice worse than the regular secular courts happen. Right, what happens is that in practice, Beit Din gets used very little, and that we could talk about a totally separate question, whether it's, right, why I tend to think it's a really bad idea that in practice Beit Din doesn't judge most financial cases, is it means that we lose touch with, means that large sections of Torah lose touch with reality. And that's really not a good thing for Torah. That we could say, catalog it, that it's not clear that Torah realizes the corporations happen yet, or checks, or credit cards. Really, if you read most books of halachic business ethics, La'aniyut Dati, most of them are a little bit embarrassing because they don't relate to real life circumstances in any way that makes sense to people engaged in them. They don't deal with the issue. And they certainly don't deal with the issues of how you structure a society, which are really the moral questions that we're trying to, that are really important in our society right now. Is what are the responsibilities of corporations as opposed to individuals? Right? What's the role of the corporation in a society? How do we manage things like pension funds in terms of intergenerational transfer? All those sorts of things, and we're still trying to work out exactly what constitutes a 16.7% markup, and exactly what kind of disclosure you have to have with the party before you get an exact 16.7% markup to constitute a noas Torah. I think, I don't know, noas Mammonot. I think that we're simply not succeeding in that regard, and I think the reason is that it's possible for people to happily sit in halachic ivory towers and write books without ever having to deal with case law that matters. I think it's a bad thing. It's a little bit more interesting in Israel, where they do have to deal with more cases like this, and the truth is that in the Haredi community, there is more in Monsey and Borough Park, and right, there are Beit Din that are more serious. The RCA is a little bit, right, is starting to take it a lot more seriously, but we still don't have anywhere near a body of law that addresses these issues, and particularly, as in many areas of Halakhah, we have to figure out what we do in a system that's designed to have legislation and interpretation. When we don't have legislation, interpretation needs to take a larger role. And we have not, so far in financial matters, we have not really taken on the responsibility of figuring out of taking the larger interpretational questions that have to address seismic shifts. So we have people like Rav Herzog or my teacher, Rabbi David Bleich, who say, if we wanted to implement halachic financial law, the first thing we have to do is make the following 10 takanot. Which is fine, but we're not making those 10 takanot. I think it's not a great idea. I think it would be great if we could slowly build up a set of, I think we should probably start here in Boston. I keep being tempted to try it. Let's start with the halachic small claims court. Now you should know that when Beit Din when people sign arbitration agreements for Beit Din, they almost never sign agreements asking Beit Din to judge according to the Halakhah. They almost all sign agreements asking Beit Din to sign according to pshara or pshara karov l'din, which basically is a concept of equity, and basically you're using your dayanim as justices of the peace as opposed to as judges, who are making communally appropriate decisions, because we understand that no one is making their contracts on the assumption that strict letter halacha is what is going to govern them, and furthermore, no one really knows what that would be, because there's no trail of binding precedent. So I think small claims court is probably the the first way to try it, and hopefully you get a few larger cases as you go through, and you build up a case law that binds you, and you build a precedent that could go there. Okay, that's a theoretical question we could talk about at great length. Another point of what it would take. Also, should point out, and this the RCA and Rabbi Yonah Rees gets credit for, no reason that the judges on a panel like this should all be rabbis. Right, so there should be professionals who are involved, and one of the things that you want to do is involve people with good common sense and some basic halachic knowledge and a lot of knowledge of the reality on the grounds, and bring them in as panelists on every case, so that you have expertise on the court. Otherwise, I think that most of us, most of the rabbis who do not have extensive business experience will end up having or accounting experience, will end up having circles run around us. So I think the RCA has done a tremendous job that way by making sure that it has panelists available who know the specific professions, and that any panel that requires knowledge of that area, they try and make sure they have a judge on the panel who can explain those things to them. Eventually, hopefully the judges get their own independent knowledge, because you don't really want to be reliant on one person to give you your whole view of a field. Okay, but as I say, that's, in theory, the system we have now basically involves bypassing Beit Din entirely. But at the least, as long as Beit Din is reasonably responsive, when one party shows up and asks for heter hakod, and the other party refuses to show up in Beit Din, so we're fine. What would be worse is if people can use the Beit Din system as a way to create injustice specifically. Now, how could that happen? So it happens, as explained earlier, if you require the person who's willing to listen to Beit Din to go through a case twice. I mean, you require them to go through a case in which they will listen to the outcome if they lose, but the other party will not. Now, how can that happen? So we thought, so the easiest way to happen is if one party, this used to before we required binding arbitration agreements, so a party would show up, argue the case, and then lose. Right, then lose, and then go to secular court. And all you would have done is disclose your legal strategy. But we solved that. The binding arbitration agreement requirement takes care of that. But what happens if the other party can generate a conflict about whether they are or are not willing to go to Beit Din? And that conflict paralyzes the Beit Din system, such that you cannot declare that the other person has rejected the authority of Beit Din. So now, even if this, so now, if one party can freeze the court system and say, you know what, I'm willing to come, just are these conditions that have to be met. And the other person says, but I'm not willing to meet those conditions, and the Beit Din has no capacity to determine which conditions they have to accept, right, then at least defendants can always tie up the system forever. Right, now, how could that happen? So to figure out how that can happen, we need to take a look at. Okay, we need to turn to page 4. Okay, we'll start, and then we'll have to turn back. Let's go to page 4. Okay, page 4, a very famous Mishnah in Sanhedrin. It begins by saying, Dinei Mammonot b'shlosha. All financial matters have to be judged by 3 judges. Okay, that's really a citation from the first Mishnah of the Masechta, which gives you a list of how many judges are required for each thing. So it's sort of it's a recapitulation. But here we are. Now it gives you the pattern by which you pick those 3 judges. Zeh borer lo echad. This one picks one for himself. V'zeh borer lo echad, and this one picks one for himself. U'shnehen borin lahen od echad, and the 2 of them pick another one according to Rabbi Meir. V'chachamim omrim shnei dayanim borin lahen od echad. So it looks on the face of it that the standard mode of dealing with financial cases is ad hoc courts. If 2 parties have a dispute, each of them picks a judge, and then depending on how you handle the pronouns, either the 2 litigants or the 2 judges pick a 3rd judge. That's probably the two. We'll see in a moment. The 2 litigants pick a 3rd judge. That's Rabbi Meir's position. The Chachamim Omrim Shnei Dayanim Borin Lo Echad. The 2 judges pick a 3rd judge. There is no mention in this in the Mishnah of any notion of fixed courts for financial matters. Nonetheless, halakhically, it has always been presumed that the default setting is there are fixed courts, and this is a setting. All right, this possibility of ad hoc jurisdiction takes place only in one of two cases: when there is no fixed court, or where both parties agree they would rather go to an ad hoc panel than the fixed court. Okay, so let's take that as a given, that even though it's not in the Mishnah, that the default setting in Halakhah is we have a civil court system, and people should go to that civil court system. Every city will have its own court with compulsory jurisdiction in civil matters, and it's only in the absence of a court like that, or the agreement of the parties, you go to this system called Zablo. Right? Zablo is an acronym for Zebar Lo Echad. This one picks one for himself. Okay, the Gemara goes along and says, we're not really talking about that case. We're really talking about a case where each of them picks a different court. Right? So the Gemara says, this case is not coming up because the parties are amicably deciding to choose it this way. It's coming up because the parties have a conflict as to which court's jurisdiction they wish. And it sets up all sorts of circumstances in which parties can have reasonable disputes. You can have disputes because you live in different areas, and then we have rules. You can have disputes because one of you requires a court with a higher status, and the other of you requires the court which is closer. Right? There are all sorts of, in the case of the Gemara doesn't mention, for example, I want a Sephardi court, you want an Ashkenazi court. Right? I want a court that, or as anyone knows in the United States, there are courts that are famed for being conservative and courts that are famed for being liberal. And so if you're a business, you might want to go to the conservative court, and if you're an individual, you might want to go to the liberal court, right, depending in particular areas. So for all those reasons, you might have a conflict, right? You might have a conflict among the parties as to the jurisdiction you want also. So in that solution, right, and that's what the Gemara says is the solution to cases where there's a legitimate conflict of jurisdiction, where the system is frozen, neither party has the right to coerce the other to go to his chosen court. So the solution is let them pick an ad hoc panel. Okay. Then the Gemara quotes a statement of Yidam Arav, which seems at the beginning not to have so much relevance, but in the end will have a lot of relevance, where it says, by the way, witnesses shouldn't sign documents unless they know the people who are signing together with them. Which means also that judges shouldn't serve on judicial panels unless they know the other people serving with them. And that creates all sorts of issues in Zabla, because why should I know the other person's, right? If we have two people, one of them's living in, one of them's living in Milton, and the other one's living in Randolph. Why should they know the judge the other party picks? So if you assume that there's this great network of communication among rabbis, and they both pick rabbis, maybe. But the odds are that they'll pick somebody who they know because they was their rabbi in college or something. You're not going to know them. Or they'll pick somebody they read about in the papers. So this already creates a problem that you see inherently when you don't have unless you have a licensing system. But we don't have a licensing system. They can pick whoever they want. So we're going to start to run into trouble. Okay, Rashi there says, right, why does the system work? So Rashi says, his language is very careful. He says, the Gemara said actually at the end it is when one of them picks one court, the other picks the other court, and those two courts pick a third court, then, the Gemara says in the end, one of them picks a judge, the other one picks a judge, and the two pick another judge, the law comes out truthfully. Yitzeh Din La'amito. Okay, so the Gemara seems to think that this is kind of an adversarial system model, the way the U.S. works, that we think truth emerges dialectically. And if both, or at least it emerges well out of competition, two sides fight it out, and the stronger side wins. Okay, now we know in America there are lots of challenges to that. It's not always the case. The side with the better lawyers wins. But this is the model, right? That there'll be that if we cannot find a court that's outside both litigants, we'll get both litigants to agree, and that way the judgment will come out true. Rashi transforms that. Rashi says Yitzeh Din La'amito. It's not even clear what his text was, because if you read Rashi, it sounds like something else entirely is going on. It says that Tzai Bali Din, and Rashi says because the litigants will agree, because the Savar Achayav, because the one who's found liable will say to himself, Aryeh ani ba'atzmi birarti echad. Right, I chose the Rashi's translate on page 5. I myself chose him, and the litigant says to himself, if I had, right, if my judge, the one I picked, had been able to find any way that I could not be found liable, he would have. So if I was found liable, that must be the outcome. That's what Rashi says. All right, so Rashi's version is, it's not that the judgment comes out actually true, it's that the litigants come out believing that the judgment is true. And so for Rashi, the purpose of the adversarial procedure is to ensure that both litigants come out accepting the law, as opposed to a claim of truth. Okay, so now we have the law of Zabla. We know that there's this option. So now here's the case that causes all the difficulty. What happens if one party wants to go to Beit Din? Let's suppose they come to the Beit Din of Boston, and they say, we want to settle this case in your Beit Din, and we are willing to sign a binding arbitration agreement to that effect. And the other party says, well, you know what, we don't want to go to the Beit Din of Boston. If we had our choice, we would go to some other Beit Din. We're not even going to bother that. We're going to do is going to say, we insist up front, it has to be a Zabla. It has to be a case, right? We want this case where each party picks another, where each party picks one judge. Okay, so now they're within their rights. Right, they're within their rights, unless, at least on the surface, right? On the surface they are within their rights, and now we have a conflict. Right now we have a conflict of jurisdiction. What do? Do we force the party who was willing to go to our Beit Din? Now they have to accept the Zabla, and if they're not willing to accept this system, then they're stuck and they can't go to civil court. Or do we say, no, you have no right to insist on Zabla, you have to come to our court? So that controversy rests on largely on, if you go back to page 3, so you'll see that the very bottom of the page of the footnote section, there is footnote 13, footnote Yud Gimel, that goes to the Netivot HaMishpat, which is one of the commentaries of Shulchan Aruch, and what he says is the following: but if the borrower is a strong man, and if he wants to go to a different court, even a lesser one, or in a different city, he is considered compliant, and we don't apply this rule to him. So if you read this Netivot straightforwardly, it says that the agreement of the defendant to go to any Jewish court is sufficient to defeat is sufficient to declare him compliant, so that the plaintiff has to go to his court, or else the plaintiff has to give up. There's no way that a Beit Din can write any heter arka'ot, a permission to go to secular court, if the defendant is willing to go to any Beit Din. And that would seem to mean that if the defendant is willing to go to Zabla, the plaintiff either has to agree to go to Zabla, or the plaintiff loses. Now, why is it a problem? It sounds like a great system. Okay, so they have their judgment. The Gemara already happily endorses this system. So what could conceivably be the issue here? So if you take a look at, should be a page here. Okay, turn to page. If you turn to page 9. So here is a statement from Rabbi. Right in the middle of the page, you'll see there's a statement from Rabbi Yosef Gabriel Bethel for his blog spot. Rabbi Yosef Gabriel Bethel was a very interesting contemporary rabbi. Page 9 again. So here's what he says: I will be doing a series on the evils of the alternative to a formal Beit Din setting known as Zabla, Shor V'zeh Ber Lo Echad, the method of arbitration that Chazal allowed when for some reason a regular Beit Din would not do or does not exist. I was recently involved as a dayan in a Zabla kangaroo court. That is basically the state to which the situation has deteriorated. It seemed as a favor to Tuwaini, who was a great tzaddik Talmid Chacham and Bal Yisraelim. For the first and last time, it was an educational experience of the highest order. The potential for distortion and miscarriage of justice in these settings is so great that it would seem to be less of an issur to go to non-Jewish courts than to participate in such travesties. That's pretty strong language. That's pretty strong language. So now why does that happen? All right, why does that happen? So it happens because of the Rashi that we read. Now Rashi said that why do we have Zavla? We have Zavla because each party believes that the judge that they selected would do everything possible to find in their favor, and therefore they accept the outcome. So now if you turn to page should be a Torah quoting a Rush here somewhere. Here we are. Okay, if we turn to page 6, you'll see in English, right, the Hebrew starts on page 5 at the top of the page. So you'll see that the Torah, right, so now we're in the 14th century, the Torah says this about his father, the Rush, writing in the late 13th to early 14th century. Since there are some mentally deficient people who err in the words of Rashi and learn from them that the judge should turn over to find merit for the one who chose him in whose place he stands, even if he turns over matters that are not in accordance with the law, God forbid. They did not read closely where he said he reasons I chose, etc., that he reasons he will turn over for his merit more than the merit of the other, and as a result obeys the judgment, and therefore some people have the practice of choosing a trickster judge. But one who is capable of tricking his colleague into accepting reasoning that he himself sees flaws in, he is considered a distorter of judgment. Okay, so in the 13th century already, the Rush says there were people who thought that the principle of Zabla meant basically that you each appoint a lawyer. And the purpose of your lawyer is to make the strongest possible argument for your case, regardless of whether you believe it yourself. Right? As an American lawyer, the purpose of the lawyer is not to argue for the truth, although sometimes that comes up. I was very impressed that Nathan Lewin, apparently was interviewed recently, refused to take the case arguing for the unconstitutionality of requiring informed consent for mitzitza b'peh, right, for oral suction and circumcision, because he just thought it was wrong. But normally, lawyers don't have the luxury. Constitutional lawyers sometimes do, apparently. But normally lawyers don't have the luxury and are not supposed to legally only take cases they believe in. You're supposed to take cases that are plausible, and in criminal cases you're supposed to make sure the defendant has representation, and your job is to make the best possible argument for them and to try and win the case for them by any means within the law. You're not supposed to break the law, but you're supposed to use any means within the law. So already in the 13th century, the Rush wrote that there are people whom he calls chaserei dat, mentally deficient, which is very strong language, mentally deficient but very, very clever, because they were good at this, who thought that when they were appointed to be a judge on a Zavla, their job was not to be an impartial judge, but their job was to be a lawyer. And that led to a situation where who did people appoint as their judges? They appointed the people who had a record of winning cases. So eventually, you ended up with an adversarial system as opposed to a system of square dealing. Now the Rush calls these people chaserei dat. Right? He insults them starkly. He insults them strongly, and that probably is the way you would think the tradition develops. But if you take a look at page 7, at the top of the page, you'll see that the Aryeh writes the following. Nowadays, the custom is, even in Dinei Torah, I don't have the English translation, but you'll see that it's the same thing that's said. He quotes the same process. At the end of it, he says, look, second line, and when all these three have been chosen, they judge it, and that way the law comes out. Yitzei adin lamito is quoting the Gemara. Shemitov shezeh bar lecha v'zeh bar lecha, abaladin tzaisim lehem, because each one picks one, the litigants agree. So far, it's quoting Rashi. V'hadayanim kol echad mihapek b'schut mi sheberu b'chol ma she'efshar mitzad hadin. The judges, each one of them, makes the effort to find the merit of the one who chose him, as long as that is possible within the law. And the third one listens to them and judges the truth. So the Aryeh HaShulchan, of course, does not endorse shysterism. Right? He doesn't endorse, let's say, right, like the easiest way to destroy a Zavla court is that the Halakhah is if you're following black letter law, that a 3-person court goes by majority. So you vote 2-1, the majority wins. But it can only reach a verdict when each party has made up their mind. So if one of the judges says, I can't make up my mind, you have a hung court, even if the other 2 vote one way. Because halakhically, to be a court, you need a verdict signed by 3 judges. So classically, the easiest way to completely destroy a zav law was you would argue until you thought you had a majority, and if at the end it was clear you didn't have a majority, you would say, I can't make up my mind. And you would just freeze the court. So the arbitration agreements we sign nowadays prevent that by saying that we hereby empower the court to make a decision even if there are only 2 justices can reach an opinion. So basically by signing an arbitration agreement in advance, you can solve that problem. But what happens fundamentally is that you have two reasonable halachic opinions. You have the opinion of the Rosh, which says that really the judges are supposed to be impartial. We assume that the guy who appoints you you'll like, so you'll make sure that you don't miss anything on him. But you're supposed to be impartial. But you have the opinion of the Aryeh, which says that really you're supposed to be a lawyer, but you're also supposed to be an officer of the court, so don't do things that are dishonest. The problem is that what the boundary between honesty and dishonesty is very unclear, and particularly, a reasonable person can look at the Aryeh and say, my job is not to reach the just conclusion. My job is to find all the legally reasonable arguments that my client is right. And legally reasonable and just are not the same thing. So you can have a circumstance in which one person picks a judge who sees his job as being a rush borer, and he's just there trying to find the truth. And the other one walks in assuming it's his job to vote for the other guy and to pull every trick in the pot, right? So you have one rush borer and you have one Aryeh borer. Right? That's the way. Now that's what happened to Rabbi Klapper. Rabbi Klapper walked into a zabla, assuming that he was a rush borer, and the other guy turned out to be an Aryeh borer. So he goes completely sandbagged, because he thought he was there to determine the truth, and really what he was walking in was the court was 1-0 against him to start with. And when they picked the third judge, he thought his job was to pick a judge who would really be fair. But really the other guy thought his job to pick a judge who would agree with him. So he was, and the court got tied up in all sorts of procedural technical things, the way it will in a high-powered American court, and he thought it was a kangaroo court. There was nothing to do. So let's say, in the RCA, what they will do is the arbitration agreement will say not just you have the right to pick the court has the right to make decisions when only 2 judges as opposed to 3. It will also say, and the litigants agree that the constitution of the court will be in accordance with the rules of the Rosh as opposed to the rules of the Aryeh. But the problem is, who enforces that? What do you do if the other party picks somebody who is what we might call a known Aryeh borer? Right? Let's suppose Rabbi Willie told me once. He says, I don't know anything about this person's honesty. All I can tell you is that he's been a borer in 46 cases, and he's voted for the person who chose him all 46 times. Could be a coincidence. Maybe he only takes winning cases. But the Beit Din says you're not allowed to tell the case to the person you pick before you say it. So it'd be really pretty impressive if he only picked winning cases, if he didn't actually know what the case was before taking it. So how do you solve this problem? Because really, what comes down to it is that in an unregulated zav law, right, if there's no party overseeing the legitimacy of zav law, so the honest party is going to lose. If you happen to have two honest parties suing it, right, in court, they just want to know the truth, zav law is a glorious system. But if you have a system where either party sees the purpose of going to court as winning, as opposed to, right, and the purpose of a court is to have a clash of interests as opposed to participate in the shared interest of finding out the halachic and moral truth, then Zavla simply cannot work in an unregulated setting. Now the problem we have with this is we have that Netiva, right? So I read you the Netiva on page 5. The Netiva said that if the party wants to go to another legitimate court system, this was again right at the pages 5 and 6, right? All right. No, sorry. No, it's just one. Where's the page? The bottom of page 3, sorry. The bottom of page 3 again, the Nesiva said, but if the borrower is a strong man and wishes to go only to a different court, even a lesser one, or in a different city, he is considered compliant, and we do not apply the rule of strong man to him. Meaning we don't let you go to secular court. So on the surface, right, if you try and impose any kind of regulation on a zabla, and say that you have to go to a zabla, you can only force let's say you tell the defendant, you can only force the plaintiff to go to zabla if you sign an arbitration agreement that says that two justices by themselves can decide the court if one of them tries to hang it. And you can only go to zabla if everybody agrees that they function by rush rules as opposed to Aryeh Shulchan rules. And you also can only go to zabla if you agree that the fixed Beit Din of the city gets to determine whether review the judgment and determine whether the judges have in fact followed the rules of the rush as opposed to zabla. So the other party will come back at you. Here I'm just channeling a real case, which I'm involved in. The other party will come back at you and say, but how can you say that? There's an asivos. And asivos says that as long as the defendant is willing to go to any kind of Jewish court, you cannot see them as being in contempt, and you cannot give permission to go to secular court. Okay, so the only thing is that it's a really compelling point, but it's wrong. Here's why it's wrong. So if you look at the Nesivos, right? So we're back on page 3. So you'll see the Nesivos is footnote 13. Okay, and footnote 13. If you go higher up on page 3, right? We're in the right. So you'll see right. Footnote 13 is right over here, which is in the middle of Shulchan Aruch subsection 4. Right. So we're on page 3. Right, we're up here. Footnote 13 is in the middle of the Ramah's comments to subsection 4. If your borrower is a strong man. Now the issue is that the law of the strong man shows up twice in the Shulchan Aruch. So if you take a look at pages 2 and 3 simultaneously, you'll see that on page 2 towards the bottom in Seif Bet, right, it says Hayta Yad Tokifa Uval Dino Alim, and your person is a strong man. And it says the same thing, Avolim Alove Olim, but if the borrower is Olim, in section 4. And the Nesivos makes his comments on section 4 and not on section 2. Now why does he do that? So the answer is that the Nesivos is talking about a totally different case. The Nesivos is talking about a case where you have signed a contract that will be enforceable under secular law but not under Halakhah. For example, a contract to collect that will entitle you not only to the principal of a loan, but the interest of a loan. So halakhically, you can't collect interest from fellow Jews. And they construct a set of cases where we know that if you go to a halakhic court, you'll be awarded, right, and you win, you'll be awarded X amount of money. But if you go to secular court and you win, you'll be awarded X plus. And the question is, are you allowed to go to secular court under those circumstances? Or, even more than that, are you allowed to, let's suppose you can't, even if you go to secular court, you won't be able to take the extra money, that's theft. But, let's suppose that two Jews make an arrangement, and one Jew lends money to the other Jew at interest, right, without using the ways to evade the prohibition against interest. And now, the borrower wants to renege on the loan. So the lender wants to take him to court. But he can't take him to Beit Din. He doesn't really want to go to secular court because he's going to go to a lot of expense and he's not going to get the interest anyway. So he has a cool idea. I'm going to sell the loan to a non-Jew. And the non-Jew will be able to collect the interest in secular court. That's where the Nesivos says, you can't do something that will make the Jew pay more than he will be liable to pay under Halakhah if he's willing to go to any Jewish court. But he says nothing about a circumstance in which it's just a straight case between two Jews, and the outcome is going to be the same justice-wise in both secular and religious court. There, the Nesivos agrees that it has to be it agrees to the perfectly rational principle that we can't compel you to go to a court unless you have a reasonable prospect of justice. But the Nesivos says selling the loan to a non-Jew, which you know will mean that he will end up paying more than he's liable halachically, right? Even though you're not collecting the money, but you are taking money away from him, right? By this secondary means, that the Nesivos says you cannot. If he's willing to go to any Jewish court, you can't do that. So, and if you trace back, which we don't really have time to do this tonight, you can see that actually a game of telephone happened, where the Nesivos is the fifth in a chain of people quoting things, and they all go back to a Tosfot, and the Tosfot was talking about something else entirely, but somebody used the Tosfot to play a new case, and then somebody else saw the first line without reference to the original case, and so this misunderstanding happened. If you look at the Nesivos in the context of the Shulchan Aruch, you'll see that it can't mean that. It's talking about the narrow case, and if you look at it back in the context of Tosfot, actually you can see we have the Tosfot on page 3. You'll see that it has nothing to do with it. What the Tosfot on page 3 is talking about the question of whether one judge has coercive jurisdiction, and the answer as opposed to a Zabla case, the answer is that that we can only force you to go to Zabla if you we can only force you to go to a single judge if you're not willing to go to any court at all. But if you're willing to go to Zabla, we can't force you to go before a single judge, even if that judge has local jurisdiction. And it has nothing whatsoever to do with the rules of Zabla. It has nothing whatsoever to do with it's just a question of whether we can compel a particular case when you have a non-standard fixed court. Okay, let's take that as a given. That there is this Nesivos. The Nesivos is used incorrectly. The reality is still that right now you have to How do you compel people to not take advantage of that Nesivos? Because right now, if somebody comes to Beit Din, right? So let's take standard case. Mr. X comes to Beit Din and says, "I would like to sue Mrs. Y because I think that Mrs. Y owes me $20,000." And Mrs. Y says, "That's very nice if he wants to go to Beit Din. I also want to go to Beit Din, but I want to go to Zavla. And the Zavla I want to go to, I'm going to pick, I don't see any reason that your court should have any control over it. I can pick whatever judge I want. He can pick whatever judge he wants. And if he doesn't like my judge, well then, he can just sue. You can't write in the Hektarah code. I have the Nesivos on my side." So that's really a big problem. And this is really to understand the way Halakhah functions right now. Being right isn't enough. You have to be right, and there has to be enough social pressure to compel the other person to give in, because the court can't enforce its own decrees. If a court said, "Okay, you know what, we're going to write the Hektarah code anyway," so then the people say, "Look, that court wrote a permission to go to secular court illegitimately." So, to my mind, the first thing that has to happen is it has to be as broadly known and accepted as possible that it is legitimate for a Beit Din to write a permission to go to secular court if the other party demands a Zabla and will not submit to the authority of the Beit Din to supervise the Zabla. Because Rabbi Klapper is entirely right. An unsupervised Zabla, in which each party just gets to choose whom they want without any oversight and without any determination as to the rules, will end up either with one party picking a corrupt judge who simply skews the proceedings, or end up in endless negotiations about the picking of a third judge so the case never comes to court. So this is one of the areas where there's a there's a theoretical solution. Theoretical solution is to say that nesivos is misinterpreted, and that really a Beit Din has the right, has the capacity, has the right and obligation to write a heter arkaot, a permission to go to secular court, whenever there is no realistic expectation that the other party, that an alternative will provide justice, even if the alternative is in theory a halachic legitimate court. And that's what's needed. Until that happens, anytime you go to Beit Din, the other part, right? If you go to Beit Din against somebody who is not fully honest, they will freeze the system by demanding as of law. They will then pick a borer who is known, right? Who is known to fight for their cause regardless of the truth, and and then if you're honest, you'll pick somebody who refuses to sit with that person. You'll never agree to a third party, and the case is hung forever.